outrageous government conduct that shocks the conscience. In the United States of America versus Cited Case, they conducted an entire federal trial with wrong individuals named, which the plaintiff, U.S. Attorneys, and the Northern District of Ohio all knew that issues existed before the trial. That means that the actual principal adverse party whose order and judgment is sought and sustained did not participate in the proceedings and was deprived due process of law. This case is a published case. It's set case law. It is a cited case. There's academic papers citing the case, and it appears to be using incorrect, inaccurate, false, erroneous facts. Reckless disregard of whether the statement is true or a conscious effort to avoid learning the truth can be construed as acting knowingly. An individual is not relieved of the consequences of a material misrepresentation by lack of knowledge when the means of certain truthfulness is available. You'll see within the docket of the case, docket number 14 of the case management, you'll see here that the FDA will visit defendant's facility, and you'll also see here that the defendants will make proprietors and managers available for deposition. And here you'll see that's within the order. So clearly the FDA, the plaintiff, and the U.S. Attorneys had the ability to see the truthfulness of the information that was presented. There is a YouTube of federal trial with wrong individuals named that has a lot more detailed information. You can examine this. Here are the statutes of deprivation of rights, the conspiracy against rights, perjury, also false declarations before a court is 1746 as well. General false statements of knowingly. Further, that there's a declaration that doesn't appear to have a date to it, and Federal Rules 11, representations to the court. Further, the Department of Justice mission statement is to ensure fair and impartial administration of justice for all Americans. So I believe that there are false declarations before the court, which I believe that's a crime. I believe there's issues of perjury. I believe there's subordination of perjury. I believe there's sworn declarations of it being undated. There's issues of false statements, I believe. There's issues of deprivation of rights under the color of law, issues of not having a fair trial, Sixth Amendment violation, Eighth Amendment of cruel and unusual punishment, the conspiracy against rights, Federal Rules of Procedure 11, representations to the court. I believe there's issues definitely with that, and the issues of candor to a tribunal or failure to correct statements. Further, there's Rule 19, requirements of joiner of a party, and that would fall under Rule 11, under the failure to join under Rule 19. So I believe under Rule 19, if there's a failure to join, that raises issues of lack of subject matter jurisdiction. So on an issue of lack of subject matter jurisdiction, a court determines at any time that if it lacks jurisdiction, the court may dismiss the action. Further, on issues of lack of subject matter jurisdiction, that it can be raised at any time. And habeas corpus also, if there's a lack of subject matter jurisdiction, that it can be raised any time, and you have a constitutional right of habeas filings. Additionally, under the Federal Rules of Civil Procedure 12, hearings before the court. So if those defenses between Rule 12b1 through 7, if they're made by pleading or motion, which there was a motion to have someone dismissed because of improper party, those are to be heard and decided before the trial, unless the court orders a deferral until trial, which I don't believe, if you look through the record, that happened. So I believe there's rules of civil procedure that were not followed. And that raises issues, too, of the Code of U.S. Judges, is if there's an issue within the filing that it says that there's improper party's name, then it would imply that there's another party to an action, or there's a John Doe situation, which a judge swears that that should accord every person with a legal interest in the proceeding, the person's lawyer, a full right to be heard according to law. So if you've been told that there's wrong parties here, it would appear that the court knew that there were problems and should have addressed those before you conducted a federal trial. When I discovered those issues, I had filed something with the Northern District Court in, I believe it's the case 500CV1A82. Additionally, there's further legal issues that in case 501CV0709 that I was permanently barred the use of filing any new lawsuits with the court or other documents with the court. Now that was done without a hearing, no right to be heard. It doesn't seem to enumerate or discuss all relevant factors. I believe it's unconstitutional, and I believe it creates irreparable harm, and I believe that it's a continuing violation of the First Amendment. Additionally, that is within my YouTube of violating First Amendment. You can examine that one, and it goes into more detail and supporting information with that. Now, so under Rule Procedure 12, Defenses and Objections, hearings before trial. So this matter should have been addressed before the trial, and it doesn't appear that they did that. So I believe there's serious due process issues and procedural violations. In addition, I believe that there's misrepresentations by the manner and method in which, or material facts which they presented to the court for these proceedings. So let me get into that. I believe the plaintiff knowingly misrepresented the methods, manner, and conditions in which the cheese were manufactured. Union cheese had a high temperature short time which was set above 161, and that was before the FDA completed its November 29th through December 14th, which they placed in the EIR report of it being unpasteurized. So Union's process does not seem to fall within 758.439 cheese from unpasteurized milk within that definition. It appears to exceed that definition. So Union was implementing two forms of bacterial destruction. It appears that the plaintiff is clearly misrepresenting the manner and method of production. They had the opportunity of the 3 days to visit the facility and verify the method, manners and method. So the plaintiff filed the case regarding pathogenic bacteria. It does not seem to, however, have tested any of the 200-pound blocks or even during the court-ordered inspection. Further, it does not seem to have conducted an alkaline phosphate test to see the performance of the high-temperature short time. Where this becomes critical is the testimony by Madden, their expert witness, in which he testified pasteurization kills off Listeria mono. He further went on to testify regarding the possible levels and the ineffectiveness. Well, that becomes problematic because the witness seems to lack sufficient knowledge or information to testify to actual matter and methods of the possible levels. And let me go further and explain that. The expert witness seems to have materially omitted the bacterial destruction in Union's process. Further, in his testimony, it does not seem to indicate of what he started his analysis with. So if he testifies to possible levels, what was the beginning numbers that he started with? So there's no indication of a silo sample. There's no indication of what he was accounting for the high temperature short time and Union's method of what that device, what the bacterial destruction would be. He doesn't account for that Swiss is a cooked curd, and so what numbers would you give to that, because it forms very well, consuming the lactose and glucose is starving off the Listeria. Further, well-established law provides the process of using it, so it appears that he's conflicting with existing law that allows the process which the government had approved. Further scientific studies tested use 10 to the 4th to 10 to the 5th, and he uses 100 CFUs, so that's skewed of why he's using that low of a number. Additionally, there's issues that it's a low moisture, high acidic cheese. Further in his analysis, it doesn't mention of any steps that union takes before packaging, and there's also FDA policy or allows for reconditioning. So we don't know exactly how he's determining certain steps. And finally, all the cheese tested negative for listeria, as well as we don't know how he calculated, because there was a court-ordered search and no listeria mono was detected in the facility. So how his analysis of how he was determining certain things, I believe, are important. So real briefly, again, you could look in my YouTube and it gets into more detail, but you'll see that there were things filed with the court, so the court clearly knew that there was issues. You'll also see here within Docket 13 regarding my father, saying here at that point, for personal reasons, I elected to take less active role in the day-to-day operations. So it appears the court knew that there was issues with the named individuals. And again, non-joiner of a necessary party, I believe, impacts the validity of the judgment and issues of void. Before, I was kind of reluctant to name or put individuals that had knowledge. In this particular video, I decided I would put names of individuals that would have knowledge of who can testify, who handled the day-to-day operations, or would know certain facts, either a little bit or completely. And the people in red here would have knowledge of issues that it seems to conflict with stuff that's within this court order. So there are about, I believe, over 100 individuals that would have direct knowledge, either that were at the facility or daily or regular communications of a certain part of operations. So they would have together there would be a totality of, we would know who handled the day-to-day operations of the facility, and issues that the declarations that they submitted before this court, there's clearly something wrong with them. Also, again, it's in the YouTube, but you'll see the declarations that was filed in the initial complaint said it was derived from the paperwork. I believe that was Merzelli. Well, it'd be interesting to examine all of the documents, because it seems to suggest it could not have been derived from the paperwork. Further, you'd want to either question or wonder is how many weeks the FDA was at the plant in approximate hours, and how many times they witnessed the named individuals in the plant. Further, you'd want to know is who were they with during the entire time within the facility. So there would have been hours that they spent. I accompanied them throughout the whole entirety while they were in the facility, and many times within the office when they were discussions. So there were countless hours I'm with the Food and Drug Administration, and to omit my existence is absolutely outrageous. Further, that there was things within the EIR report placing things in production, so I don't see how they would have named my sister in this action at all. Further, you'd want to examine have him testify to what was within the examine or question Philip or the investigators at what was the high temperature set at on December 11th, as well as the 12th through the 14th before you left. What was that temperature of that device? So I believe there's clear issues that the FDA materially misrepresented the manner and methods and conditions which the cheese was manufactured. Further, I believe the plaintiff, U.S. Attorneys, and the Northern Court willfully circumvented well-established law of 7 U.S. Code 58439, cheese from unpasteurized milk, as well as 21 Code of Federal Regulations 133-15-195 Swiss cheese, allows that it can be raw and used within raw milk within the process. The FDA had reported that there was 13% of the Midwest commercial milk contained listeria. However, the plaintiff imposed a zero tolerance policy of listeria mono for the entire facility. So I believe that there's issues that there's deprivation of rights under the color of law and conspiracy to deprive rights. I believe the union had a privilege to use raw milk. I believe creating a zero tolerance policy for listeria is arbitrary and capricious. I believe it violates the Administrative Procedures Act. I believe there was issues of unequal justice under the law. It was not being uniformly applied. Further, there was issues the FDA mandates were creating a class of people with different rights and different obligations. And further, there were issues of whether there were Fourth Amendment unwarranted search and seizures. Was the FDA inspection unreasonable? Was there unreasonable time, unreasonable limits, unreasonable manner, unreasonable promptness? The FDA court-ordered search, there was no Listeria mono found. Further outrageous is publishing a notice of a proposed final rule making in the Federal Registry and providing opportunity for the publication for public to comment on notices of proposed rulemaking is to occur before it is put into effect. With the FDA, it appears that they were creating policy of no listeria throughout the facility, and they were not conducting any rulemaking. Further, is an injunction is to preserve the status quo. The relief involved is to prevent the opposing party from specific actions or continue a current course of action. So it would appear that the FDA was violating or should have been stopped of implementing this policy. Is they were changing the status quo. And so for the zero tolerance policy of listeria for the entire plant, I believe it is an irreparable injury was threatened. And if that's is a violation of the Administrative Procedures Act, the notice and the comment requirement is one example of a deprivation of a procedural right. So I believe that there was irreparable injury being inflicted on union with the FDA's policy. Go through the public comment period and it was not being uniformly applied. Now, the most outrageous, egregious of government conduct that should shock the conscience is the plaintiff, the United States of America, appears to have made statements of it being virtually impossible regarding the June 16th order, and this was before the judgment of the 23rd was entered. And there is an affidavit, and it appears to have been filed with the court regarding that. Now, issues of impossible. The order imposed a zero tolerance policy as well as other pathogenic bacteria within the facility. So basically, the court order seems to be wanting sterility. Again, the FDA had reported that there was 12% of the commercial raw milk supply contained Listeria mono. Further, the raw milk supply is normal ranges is 10 to the 4th to 10 to the 5th CFUs per millimeter of microorganisms. So here this court order is wanting zero throughout the whole facility. So is there issues that this means that the court order, is there issues that it was cruel and unusual punishment? Also, the order is significantly harsh with no limits to the mandates of mandates or the presence of the FDA in the facility, as well as the fees imposed. Also, is this order illogical? Does it conflict with well-established law? And does it seem to circumvent federal law? So there's numerous, I believe, issues with this order being impossible. Now, if this order is in fact impossible, that means the successor corporation and all those in active concert or participation with them would appear to be violating this court order. And some of those in participation would be the FDA, because there was requirements for them to sign off and things, as well as I believe it obtained USDA approval. So there would be federal agencies in active concert or participation with the facility, and if this order is not possible, there's issues that the federal government is violating their very order that they mandated. Further, it would be countless individuals would be violating a federal court order, which the government knows, and they're violating it with impunity. So you have one class of people that they're aggressively enforcing, and another class of people with exact same facility and all, not enforcing a federal court order. So further, if there's wrong individuals named and the June 16th order is impossible, there's issues that within that court order, the court required you to disseminate the order to other people. Well, if it's false information, you're actually under court order then of disseminating false information, and as well as the public is using it for case law or publication. So at no point did the government ever attempt to correct things. This was not a mistake by individuals. This was not an oversight. This was not misjudgment on the part. This was a complete conspiracy by officials. I believe that there are countless issues of probable cause to believe that crimes happened within this case. I believe that it is outrageous government misconduct. I believe it's absolutely egregious. And you could look at my YouTube. There's a lot more information that I get into. I'd like to thank you for your time.